Welcome back, folks. Okay, if you like this video, please consider subscribing, liking the video, selecting the additional notifications so you'll get notified when I make other uploads. And please manually share this. If you're on Facebook or any place with groups where people are trying to learn more about doing things pro se, I've done a number of cases now. I feel like I've been very successful with my attempts. This may be sitting an appeal, but everything I did was on the money. The court systems are just very corrupt, and there are people that aren't competent making the same claims, but they haven't put in the time and effort and energy to actually study the statutes, the codes, how these things are supposed to work. They're just they're just winging everything. Oh, none of this stuff applies to me, blah, blah, blah. Some of them may be federal snitches, plants, whatever you want to call it. Like just people out there that are intended to, mislead others. You're going to have to put some work into this stuff, folks. All right, so this is the second video in this section. We're going to go through the statement of the facts. All right, so on November 11th, 2016, Officer Clarence Davies III conducted a seizure of Philip Bickle, defendant appellant, and his automobile over alleged traffic violation. Okay, anytime you go through a so-called traffic stop, that is considered a seizure. You've been seized for Fourth Amendment purposes. This is well established in federal and state law. Take the time to research that, though, to confirm and make sure that this guy knows what he's talking about. At our second section, on November 17, 2016, Officer Clarence Davies III filed citations number blah, 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 and blah, blah, blah. First one being for the criminal side, the no driver's license and no insurance. The second one being for the infraction side, which was 4 things he tried to hit me with. Let's see, that included no license plate, no, no tax indication, no registration on person, and failure to register, I believe it was. I'll have to look that up, but that'll be a separate video because I have an appeal for this one that was separate, and then later the appeals court went ahead and merged these 2 things, which is what the lower court should have done, but these people were knuckleheads. Okay. All right, so they were filed at the courthouse in Hawaii alleging violations of the Hawaii revised statutes, and these are the 3 chapters. This one is the no driver's license. No driver's license, and I believe a couple of the infractions. This was for the insurance, and this would have been one of the other infractions, I believe the registration. Okay. An unknown court clerk took these citations and treated them as if they were filed by a prosecuting officer, also known as a prosecutor, who is authorized to initiate criminal prosecutions on behalf of the people of the state of Hawaii by the filing of a verified charging complaint with the clerk. Court cases were created under the same numbers of the citations. So to be clear, there were 2 cases created for multiple alleged offenses from the same episode. Now, here we have a citation. This is how they should generally look. Depending on what state you're in, you may have a slightly different formatting. Maybe this is bolded rather than italicized, but that's something for you guys to look up on your own. Now, the record on appeal is what the court clerk will send up. it's the only info available to the appeals court for making their determinations as to whether or not the issues you raise are valid or not. Okay, I made a first appearance on December 15, 2016, before Judge Harry Freitas. I made an oral motion to dismiss based on the grounds that no charges had been filed or orally entered with the trial court by a prosecuting officer who is authorized to initiate criminal prosecutions on behalf of the people of the state of Hawaii by the filing of a verified charging complaint with the clerk or oral recitation before the court, and because I had letters in which the prosecuting attorney had tacitly agreed that his office had not initiated prosecution against me on the matter. This oral motion was dismissed, and I was told to file a written motion to dismiss, even though, as I had pointed out, I had not been served with any charging instruments by the prosecution. Okay, this, let's see, this is part of the, number 24 is part of, I guess what would be called the docket for the appeals, appeal on this. Let's see. Yeah, the official transcripts for that day I had to get. If you're indigent, if you don't have a lot of money, you can many times get these for free. There's a code over here for it, and I didn't know about it at the time, and I got screwed. I got hit for quite a bit of money to get these stupid things made for me. So dig into that on your own, depending on what state you're in, and if I remembered it, I would tell you for Hawaii, but I don't. I know it's there. It's buried in the statutory code, I believe, in the criminal section. All right. On January 3rd, 2017, appellant defendant filed motion to dismiss for lack of all jurisdiction, along with Hawaii Supreme Court state law library certified copies of selected relevant portions of the Hawaii revised statutes, Hawaii rules of evidence, and Hawaii rules of penal procedures. So the record on appeal, these docket numbers 7 through 12 are all some of these filings, and then let's see, 6 was the actual motion, so that you have each of these things, you can later refer to them. But this is also what gets them to look at it and establish, that yes, you did this thing, it's a fact. Let's see. On January 13th, 2017, the prosecuting attorney filed State of Hawaii memorandum in opposition to defendant's motion to dismiss for lack of jurisdiction. That was included. It's an established fact. They did that. On January 24th, 2017, a hearing was held for defendant appellant's motion to dismiss in a prosecutor's opposition, which the prosecution had failed to serve upon the defendant. At this hearing, Prosecutor Brianne Larius informed Judge Udovic of this failure to serve me in a timely manner. Defendant appellant was told by Judge Udovic the court doesn't deal with briefs on those particular days due to traffic caseload. The hearing was rescheduled for March 2nd, 2017. If indeed it was a fact that such briefs were not handled on that day, then the matter was delayed by a scheduling error of the court. The ADA representative had already been contacted on December 5th, 2016, to be informed of the fact that defendant appellant suffers from chronic pain in the legs, and the scheduling error, which should have been readily foreseen, caused more pain and suffering. I may have to record all this. I don't know. My AC unit just kicked on and it's blowing right on the mic. I can't pause this recording easily. Okay, so the other thing is, on this day, I didn't include this, but I have evidence of this. When I was waiting for the hearing to start, the prosecutor, Brianne Larios, came up to me and actually tried to hand me their filing for that day. She was telling me it was a courtesy copy, and I said, that's not proper service, and you know it. And she's just stuttered and stumbled over her words. She couldn't form a sentence. She just walked off. She didn't know what to say because she didn't expect to have a pro se litigant call her out on the fact that it was improper service. They're supposed to give you, time to look over what they're going to file, and she wants to give me something right before the hearing. So, pretty ridiculous. Plus, the judge did not. He did not make them take a continuance on that to get the job done. He just continued it for them by pretending they weren't doing hearings on those days. Yeah, the corruption in this court. Okay, on March 2nd, 2017, a hearing was held on defendant appellant's motion to dismiss for lack of all jurisdiction. And after oral arguments had been made at the March 2nd, 2017 hearing, defendant appellant's motion to dismiss for lack of all jurisdiction was denied and the state prosecution's motion in opposition was granted. I made it known that I intended to appeal this decision before trial. I also indicated that I plan to file a motion to suppress the evidence obtained by the warrantless seizure conducted by Officer Clarence Davies III in violation of Hawaii Revised Statute 803-5. I was then ordered to appear on June 15, 2017 at 2 p.m. in courtroom 2C for a bench trial. Now, make note, I haven't said that I entered a plea at any point so far, and it's because I hadn't. The judge hadn't asked me to enter a plea at this hearing, and at the prior hearing, that was dropped because I pointed out that, I had a motion to dismiss and prosecution hadn't been initiated. So there's no plea on the record, and they set a trial. they they couldn't even look at their own docket to see that there was no plea entered. They couldn't be bothered to do all that. Let's see, how much more do we have here? Oh, this is huge. I'm going to break this up actually because I need to get a drink. Let's see. All right, so at no point in time within the statute of limitations for all alleged offenses have I been charged through a written verified complaint, nor were any charges entered orally in the common vernacular. Very important point right there, the common vernacular. Do some searches on that for jurisdiction also, because if they don't give you charges in terms that you understand, which means no legal terms, then they haven't apprised you of the nature and cause of the proceedings against you. And that alone, I've seen in appeals, cases get overturned. So I have things left and right that could get this overturned. It just depends on the honesty of the court above, and that's if they even rule on this. Okay, so blah, blah, blah. In the common vernacular, by a licensed prosecuting attorney on behalf of the people of the state of Hawaii. I keep putting that phrase in there because I'm emphasizing that point, that I know how this is supposed to work, that they're not allowed to have a cop create a case. They don't have a license to practice law. Okay. In addition, at no point has a summons been issued by a clerk of court That's a required element. They have to issue a summons with a copy of the verified complaint to you, and then once the service is complete, the process server will provide the prosecutor with a copy of the proof of service, and that prosecutor is supposed to enter that into the record, so it shows they've informed the defendant and provided a copy of the complaint. But none of that's in the record. And again, they don't expect somebody, a pro se, to come in there and start calling them out on procedural violations left and right. All right, so these sections here all provide proof. Okay, I filed an opening brief for interlocutory appeal with the Intermediate Court of Appeals. This is something else I need to do another video on. Most people aren't familiar with that, and it is a collateral attack. We'll get into that later, though. I'm going to go ahead and stop this right here.